A very warm welcome to all of you. This is our live answer writing session. So today we'll be starting with General Studies Paper 2, which consists of polity, governance, and international relations. So most of you have read Lakshmikant to brush up your basic concepts. But in mains, what is being asked in UPSC is altogether a different game. So let's say if you have read about president, its powers and its, let's say, functions. But in UPSC, they will ask you about the whether president as a union executive, his working is, let's say, is important or not. Whether he is getting influenced by the appointing authority, right? Or whether its position in the present scenario is, let's say, useful or not. So they will ask you the major issues going on with respect to that particular topic. Clear? So in even though you are writing a question on a, let's say, on a more critical thing, but you should know the basics of that particular topic. If you know that president is mentioned, let's say, under article 52, the pardoning power are mentioned under article this, so it will help you to write a better answer. So knowing the basics is very important to write a good answer in mains. Clear? So we'll be starting with GS2 and we'll be dealing with the polity thing. So before starting, let me tell you our one initiative. It is basically the Ustaad mentorship program, right? So we are focusing basically on this revision plan. So those who all are preparing for UPSC 2023, if you want a mentorship program, so we are providing it. We are making it a, let's say, we are not taking much students. We have some limited seats here because we are giving a proper focus on that student. His weekly targets will be there. A timetable will be provided to him or her, and they have to follow that weekly targets. And on the particular weekend, we are having a one-on-one conversation about his achievement, whether he or she has achieved that particular task or not. So it includes all the target thing which they have to read on a weekly basis. A regular writing and answer evaluation part would be there, and the most important aspect of any mentorship is whether you are able to communicate with your mentor on a regular basis or not. So in order to do that, we are giving one mentor call on a Google Meet, so to the students, so that they can communicate with us, they can share their problem, and those problems should get easily and quickly resolved. Because if the problem is not getting resolved even after paying so much money, there is no need for such useless thing, right? Because once a doubt is in your mind, and if you're not getting it cleared, it will pile up, and this will create a problem in future. So you can read the entire course structure here. So we are not providing any kind of coaching. We are not teaching you here anything, but we are providing you all the important tools and weapons for your UPSC preparation. What to read, how much to read, and from where to read. What to write in an answer, what not to write, how you should write. We are going to tell you each and everything, and we are going to help you achieve completion of your syllabus, which is one of the most important aspect in a given time frame. Clear? So you can contact at this number for more details. Moving on. So this is our general studies paper 2 polity part. First question is anti-defection law a restriction on the freedom of choice of legislators? You have to examine it. So basically, what the question is asking, there is a law, and you have to examine the law in the light of whether it is giving a particular freedom of choice to the legislators or it is not giving it. Clear? So you have to examine. How you are going to examine? The keyword here is examine. So if you have not gone through those videos of the UPSC keywords, go through it and see what we have written. So whenever there is a word called examine in any question, you have to know the positives and negatives, right? You have to make a balance. What all the good things are there, what all the bad things are there for that particular law. Then you can make this. Yes, say there are 7 points in good, there are 6 points in bad. So overall it is good, but removing this six drawbacks, it will give more strength to this law. In this way, you have to examine. Clear? How you can examine? If you have some data, if you know some instances, if you know some good current example where these kind of legislative defection thing is there, right? So let me tell you the approach. Okay, how you would approach this particular question. So here the key word is anti-defection law and freedom of choice to the legislators. So you have to introduce first the 10th schedule. Okay, from where the anti-defection law has originated. So mention about 10th schedule of the constitution, what it meant, right? What all the procedures it has given. Clear? Then you have to write the argument in favor of restriction of freedom. Right? The arguments in favor of freedom of choice. Okay, whether you have to write that yes, the anti-defection is making let's say on restricting the freedom of choice of legislators, right? Restrictions of freedom on choice. Then you have to write what the main Supreme Court judgment was in this regard. So you have to mention the Quixote Holohan judgment. What does Supreme Court mentioned in this particular judgment? And in conclusion, you have to suggest any alternative. If you know what other alternate things can be done, you have to mention it. In this way, you would be examining this anti-defection law in the light of restriction of freedom of choice of legislators. Okay, so let's see what are you going to write. So let's write the answer. Tenth schedule, into introduction, you have to write with 10th schedule or anti-defection law was incorporated by the 52nd Constitutional Amendment Act. You can write CAA, no problem. It lays down the procedures of disqualification of legislators, right? Now mention that this is to provide, what was the main aim? This is to provide a stable government, a stable government by preventing deals or political uncertainty. All right. So the aim was to provide a stable government, because if there's no law, people will buy each other, and this has been witnessed in the recent few years back, basically in the MP government, where the Congress got the majority votes. They formed the government, but the opposition tried to use money power, and they bribed the legislators, and they took down the government and made their own government. All right. So these things are still happening. Clear? So this should be your main introduction. Now coming to the second point, you have to write about whether it is restricting the freedom of choice of legislators or not. So give a subheading: anti-defection is restricting freedom of choice. You have given a subheading. Now you have to justify it. How? So write first thing. You can even give an example also here if you know that. So you can write that the law often restricts a legislator from voting in line with his or her conscience or judgment as on most issues voting directions are issued by political parties So if your party has told you that you have to vote on, let's say, against a law, so all of them have to vote against the law, because if you're not doing that, you're going against the party rules, and it means you are defecting, so you would be disqualified. Clear? So it therefore violates the fundamental rights and parliamentary privilege given to the legislators. So you have to write here, it therefore violates the fundamental right of freedom of speech and the parliamentary privilege given to the legislator. So your first point would be this. Now coming to second point, you have to write the political affiliations of speaker, because here anti-defection is ultimately decided by who? By the speaker. So it is against constitutional duty of neutrality because in numerous instances the political affiliations of the speaker of the speaker come in the way of adjudication of on disqualification petitions, because who is the ultimate authority? Speaker. So if a speaker has some political affiliations, the judgment will be somewhat favored, and it has been seen in the past. If you know that, you can also mention that particular instance on disqualification petitions. So again, here it is restricting the freedom of choice of legislator. Then third point, very important, there is no prescribed or you can write that the law does not specify a time period for the speaker to decide on a disqualification plea. So if there is a no time period, they can easily procrastinate or let's say delay the thing. Because if let's say there is a disqualification from a political party who has some favor of the speaker will definitely try to delay that thing. Let it be. I will see again. Okay. So no time period to decide on a case. So these are the things which you can show that yes, there has been, the law is against this particular freedom of choice of the legislators. Okay. However, now you have to write the other part, the Kyoto Holohan thing, to balance this thing. We have written that yes, it is restricting the choice of freedom of choice of legislator. However, in Kyoto Holohan case, 1992, Supreme Court has declared that what? The 10th schedule does not violate the freedom of speech and association, and as it comes with reasonable restriction. So every fund, it is not absolute, there are reasonable restriction. Clear? Secondly, it is not against parliamentary privileges, which are mentioned in where? It is it does not violates Article 105 and Article 194. Article 105 consists of what? Parliamentary privileges, and Article 194 consists of what? The legislative privileges. So it does not violate Article 105 and Article 194, as it is restricted for voting only. For voting only. So Supreme Court is trying to balance it. The judgment of the Supreme Court is trying to say that no, it is not violating the choice of the freedom of legislator because it is restricted to voting only. So no violation of parliamentary privileges. All right. Secondly, the other aspect, the schedule also provide for two exceptions to defection. The 10th schedule, it is Supreme Court who is saying that the 10th schedule provide for two exceptions. To defection. That is, if prior permission has been taken from the party whip, then there would be no defection. Clear? So if a person who has taken the permission from the party that he would be voting in this line, then defection can't be issued. And the last thing, the decision of the speaker are subjected to what? Judicial review. The decision of the speaker are subjected to judicial review. So if they think that this decision of the speaker is malified or what, then judicial review can be provided. This is the most important thing. Clear? So underline this thing. Prior permission does not violate Article 1. These are your keyword. You have to show the examiner, yes, I've written all these things. Clear? So this would be your balancing thing. Now you have properly examined this, whether it is restricting or not. So first you have mentioned, yes, it is restricting. Now you have mentioned that in Kyoto Alliance, Supreme Court has told that it is not restricting. Now you have to end with a proper balanced conclusion. So give some alternative. So you can conclude with, to improve the anti-defection law further, the law can be made valid only for critical votes that determines the stability of the government. The stability of the government. It should be decided within a prescribed time frame. Prescribed time frame. And instead of the speaker disqualification can be decided by the president / governor of the state on by the president governor on advice, the most important thing, the on advice of election commission. Clear? So they are suggesting an alternative that first thing, that it should be valid only for critical votes, which actually determines the stability of the government. Second thing, it should be decided within a prescribed time frame. And the third thing is the disqualification instead of the speaker should be decided by president or governor on the advice of election commission. This should be your conclusion or the alternative you have been suggesting. If there is any other alternative, you can write here also. Clear? So this was your question number 1. Now you know the structure, how we are approaching. First we have done what? We have introduced by 52nd Constitutional Amendment Act, or let's say 10th schedule, right? Second, we have examined by what? Yes and no. For no, we have used Kyoto Holohan case as a reference, where Supreme Court has justified no thing. Now third, you have concluded by suggesting an alternative. So this is your entire structure. Now what you can do is you can write some good example, recent example of, let's say, Madhya Pradesh, where this thing has happened. All right, or you can mention some let's say second ARC recommendation, or let's say any other recommendation if you know. This will give you brownie points, your examples and all this thing. Clear? Now moving on to question number 2. See, in the previous question we have used Article 52, Article 105. These you will learn from the static thing, Lakshmikant and other static books. Clear? Now the second question is the expressions equality before the law and equal protection of the law may seems to be identical, but in fact they mean different things. You have to elaborate. So how you would elaborate so that the difference can be easily identified? First, write everything about equality before law. Equality before the law. One thing, and other you write about equal protection of law. Equal protection of the laws. So you have to write in detail about both the things. So this should be your approach. And in the approach part, how you would subdivide your question? First you have to write where, under which article these things are mentioned. So briefly write about Article 14, which contains both these expressions. Second, you have to discuss both things separately. Alright, and then conclude your answer, how both things are so important. This should be your approach, this should be your structure of the answer. So let's write, and if you know some good historical facts, you can also add on. We'll see how to add these things. So let's write Article 14 of the Indian Constitution mandates the state that it shall not deny to any person, whether citizen or foreigner, deny any person, in bracket you can write whether citizen or foreigner, equality before the law or equal protection of law within the Indian territory. Within the Indian territory. So you have introduced your answer. That here, see here, Article 14 is mentioning. Clear? So you have told the examiner. Now coming to the second point. So you can write like this: equality before the law. Okay, make a division here, and equal protection of laws. So right. So first thing, in equality before the law, it is a negative concept as it implies the absence of any privileges. Absence of any privileges. Okay. Second thing is, the concept has been originated from the principle of rule of law. Clear? Negative concept, absence of any privileges. It is originated from the principle of rule of law of the British common law. Then you can write some application. You can write application imposes certain duties on state. Its application imposes certain duties on state. On states, which are, you can write here. First thing, the state shall not provide for any special privilege in favor of any individual Okay. Second, all persons, the state shall ensure, again the state shall ensure, all persons are equally subjected to the ordinary law of the land, right? But there are certain exceptions. However, these provisions do not allow the state to. So you can write the exception that there are few exceptions carved out in larger public interest. For example, president and governor. How? So let's say equality before law, it is mentioning that everyone is equal before the law. Law is supreme. Okay. So everyone is equal in the eyes of the law. However, and because of which basically the state cannot give any special privilege to any individual. However, it is not absolute. There are all fundamental rights has some reasonable restrictions. It is not absolute. So for in the larger public interest, president and governor have given some immunity. You must have heard of, let's say, criminal immunity, right? If a president has involved in some let's say in accident or what, he cannot be punished. Clear? There are certain other ways to deal with this, but they have some immunity. Clear? Now you have to write. Why I'm writing in the column format? Because the differences are clearly mentioned here. Okay, in front of them. So equal protection of law, it basically means equals, the law would be equal and equally administered. It is a positive concept. It is a positive concept. It means law will protect equally. Means similar situation, people in similar situation will be treated as equal. They would be protected equally. So it is a positive concept as it requires affirmative action by the state towards unequal by providing facilities and opportunities. Simple. And opportunity. It means, and this concept has been originated from American Constitution. So equality before law, it has been British influence. Equal protection law, American Constitution. Okay. So this is also a good difference you can write. So the aim is here, the state should ensure the equality of treatment, under equal circumstances. For example, if a person has committed a crime, have committed a murder, all right, and let's say the person is age 24, rich background, another person who's committed crime, right, of let's say some theft, but he's from a poor background, they would not be treated equally. Equality of treatment under equal circumstances. So if a person has committed murder and another person who is also rich, or let's say other person is poor who's also committed murder, they have done the both thing, heinous crime, so they would be treated equally. All right. Clear? So that the other provision is the state should ensure people in similar situation are treated without discrimination. However, there are also reasonable exceptions, or let's say reasonable grounds are there. For example, people can be categorized on the socio-economic basis. So your EWS quota, economic basis, they have given reservation, they have categorized people. All right, so the law would be different for them, right? They have given some special privileges. Clear? They have not treated equally because they are not in an equal situation. So economically weaker section, the scheduled caste, the scheduled tribe, they are different. All right. So these are the basic differences you can write. Now, how would you conclude? So Article 14 deals basically with what? Right to equality. So right to equality has emerged as a basic feature of the Constitution. In the Indra Saune case, so you should write down the name of the case, Indra Saune case, which highlights its significance for the democracy. So this question is ultimately asking about the right to equality and its components. Further, you can write, it provides for the judiciary to intervene and protect the rights of people. So in this way, you have to conclude your answer. So what we have done, first we have introduced with Article 14, which has both the component equality before the law and equal protection of law, right? So in this way, it is identical because it is mentioned in Article 14. Both things seems what, that they are basically talking about law, how law can be applied on people, how people gets protected by the law. But there are certain differences. So you can write that it is a negative concept, it is a positive concept, it is originated from British Constitution, it has influence of the American Constitution, and application wise, what are the basic differences, right? You have given example of, let's say, president, governor have they are not equal before law, right? They have some special, these are certain exceptions. You have given the name of EWS and SC/ST quota, right? So these are your examples to differentiate, and now you have to ultimately conclude that this law is basically to protect everyone, and judiciary is the watchdog, so that the right of the people get protected every time. All right. So this was our polity question. I hope you got the hold. You are getting the hold of how to approach any question, how to write the things, how to break up the things into small parts and write. Clear? So in this way, we are going to further take the questions on governance and further in the international relation part. All right. So what you can do is, again, watch the questions. Don't watch this answer. Or if you have read this, you have watched this particular session, now go and write whatever you have learned in this session in your own words. And you can send those answer to us on this number. Okay, so this is our number. You can write, send your written answer. We'll check and we'll connect with you. Okay, because here our target is to help you write. This live answer writing will not help me. This will help you how to start any answer. And those who are already written some good answer, they will learn how to refine their answer further, so that they will be able to score maximum marks. I hope I am clear with this, and if you have any doubt, you can contact us. Okay, so I'll see you in the next session. Have a great day. Keep writing, keep improving. God bless.